Welcome to another episode of the Sous Chefs. I'm Kimber A. Russell Esquire, joined by my partner in law and my soulmate, in fact.
And I'm always Chef Rob.
And so we got some fun stuff to talk about today. First of which is the utter buffoonery and chicanery and shenanigans that went down earlier this week with the Alex Jones Deposition Saga. So, Robert, are you familiar with the Alex Jones Deposition Saga?
So I know he has like a shit ton of lawsuits against him for saying that like the Sandy Hook shooting didn't happen. And I'm like, that's some bullshit. Like that's a true tragedy. And
Truly.
he's playing with fire.
Absolutely. And he's been getting sued by various parents because they accused these kids were crisis actors. The parents have been lying. It's all been a false flag operation, to the point where these parents have gotten doxxed. They've had death threats. They've had to move. It's been, and plus they have to see the tragedy of their actual, tiny children being brutally murdered play out again and again and again. So they have not been de-traumatized this entire time. It's been such a horrifying situation for everybody. But Alex Jones has that. Now, Alex Jones has been deplatformed in a lot of ways. He still does have his own video show. I don't know if he can be on YouTube anymore, but he definitely still broadcasts, and he might have his own website. So he still has InfoWars. That's still a thing this week. So he's got hella cases. All right.
Why would anybody want anything to do with such a vile? Ugh.
Well, QAnon is a motherfucker. And there's a lot of people out here who really don't want to believe that there are people who would go into a school and just start shooting first graders, and just killing a bunch of 6-year-olds. That's not something.
Really believe that, or is this just like some I have a political agenda type bullshit? Like that's what I struggle with a lot of this like weird ass alt-right bullshit. Like like the Christian conservatives, I get it, y'all really believe that stuff, but these like weirdos like Alex Jones and Sean Hannity and them, Donald Trump, like I just be like, y'all don't really believe this shit. I know Donald Trump believes his own hype,
right?
But I know he don't believe half the lies he tells. Like, I mean, he can't, right? Like,
you wouldn't think so.
Smart, but I just feel like, how do you function as an adult believing this wild shit?
It's amazing how quickly you go down the rabbit hole, because like they've done studies on Facebook. Facebook did its own internal studies because they started putting fake posts in there, and they would try and find like, here's a housewife between the age of 35 and 40 who buys these types of things, and these are her interests based on the metrics and data that we have on her. Let's see how quick, like how many steps does it take to get Brenda to the alt-right? Apparently it's like 4. Because they start just sending more and more increasingly crazy stuff, and it starts from maybe we need to protect children from sex trafficking. Okay, sure, no problem. But then suddenly it's like, did you know that a lot of sex trafficking happens in public places? Yeah, okay, I can buy that. Did you know sex trafficking happens in pizza parlors specifically? And then the next thing you know, suddenly it's Comet Pizza all over again, and there's a sex trafficking ring in the basement of a pizza place that doesn't have a basement, just like the Alamo does not have a basement for you Pee Wee fans. But they're drinking children's blood, and there's lizard people, and the world. It's amazing how quickly people go from seemingly normal to being completely radicalized and believing the earth is flat. This is a fact. It is a fact.
He started on the flat earthers. I am never arguing with them ever again.
How can you?
Say the earth is flat. The earth is flat. I'm not going there with you.
No way.
Okay, let's hear about this asshole.
Let's hear about this. Okay, so this is a case that dates back to 2018. Now, there's multiple different cases. These are all civil cases. Some of them are for defamation, for accusing the families of being crisis actors and faking this whole thing, and they're for damages for the harm that he caused. And there's tangible harm. I mean, there's a lot of tangible harm.
Okay, let me say this. So this dude has been re-traumatizing these families for like almost a decade now.
Absolutely.
Like this was Obama.
Yes.
Like, was it his first term or second term?
I think it might have been his second term, but I do recall he famously wept when he made his address about this tragedy.
Man, Alex Jones is a piece of shit. Anyway, let's go.
Accurate. So This week was supposed to be depositions on Wednesday and Thursday. Now on Monday, and this is our favorite, an emergency motion. Doesn't everybody just love emergency motions? What's your experience of
not?
What's your experience of emergency motions for the most part?
Judges don't believe that they're emergencies, and clients believe everything is an emergency.
Literally.
Very few of these things are actually emergencies.
The emergency here is Alex Jones didn't feel like participating in the deposition. So Alex Jones fixed his fingers to type or his mouth to say, I'm too ill, I'm too sick to participate in these depositions. Now, for those of you out there who don't know what a deposition is, Robert, can you explain to us what a deposition is and why would you need to do one?
Well, it's where the lawyers gather with witnesses / clients, ask questions about like the circumstances of the case, to try to like get evidence. You know, a lot of times judges are not there, but you know, sometimes you'll object to preserve your objection. And then, you know, you can use that to, I mean, it is evidence, you know, and it's like evidence that's good because as we were talking about in our last episode, sometimes the declarant isn't available.
Absolutely.
So, but that way your attorney had a chance to question, like it was an adversarial position. So it's good to do.
Right. So you only take depositions in civil cases, not in criminal cases. We don't get to depose people in criminal cases. We have to just do it on the stand if we're going to do it. But these are sworn. So you can imagine one of the reasons why a person might not want to do a sworn deposition, Trump, is because you are under oath. So you are testifying.
Lying.
And if you suborn perjury in a situation like this, that can be held against you. But anything that you say in a deposition, because it's a sworn statement, can be used against you in a criminal proceeding as well. So, and this is why a lot of people don't like doing it, but you are under oath. And usually there's a limited amount of time that the person is available. In some cases, it's, you get them for 3 hours. That's it. For certain types of things. He was scheduled to be deposed for 2 days, this Wednesday and Thursday, so the 23rd and the 24th. On Monday, the 21st, there was an emergency hearing held by his attorneys to demand that he get basically a sick out. So the emergency was, he's sick. We're not gonna tell you what he's got or what the reason is or what the illness is or just that he's resting at home under supervision of his doctor, and his doctor said he cannot be deposed. So I want to do, because I got that improv background. I'd like to go and do a little bit of, let's reading. Do a little bit of this. So here's the thing. So these guys roll in front of this judge with a letter from a doctor, a letter from allegedly a doctor, because here's the thing. They did not get permission from Alex Jones to reveal the name, the practice area, where or if the doctor is actually a currently licensed physician, because they have to renew their licenses, just like we got to re-up our lawyer licensing every year, keep it current, got to pay all our dues, make sure we get our continuing education. The doctors have to do the same thing. So we don't even know where this doctor is, what this doctor does, or what this doctor says Alex Jones can't do. So here's what they come in. So it gets better though. It gets better because So the judge is saying, okay, so first of all, I do feel bad for Attorney Smith, who is one of the defense attorneys, because, in a lot of instances, we're partners, right? We will cover for each other because we might have conflicts. Like we have to be in 2 separate courtrooms at the same time. Can't do it. I can't just split my body and send us both to court. So you'll cover for me, I'll cover for you. But I practice mostly domestic, you practice mostly criminal now, so I might not be as familiar
Right.
And you might not be as familiar. So usually you go up and you just try and get another date. And if the judge asks specifics, like, Your Honor, I'm just covering, my partner could better do it. We could get a short date and she can come back in.
Right.
That's how you do. That's what happened here. So this guy is not the dude who wrote the motion.
Okay.
I don't think this dude read the motion. He clearly did not read that shit. Did not do it.
Yes.
Didn't read
Which
it.
we should explain isn't uncommon when you're doing coverage.
Accurate, very accurate. Like I've done coverage for colleagues at other law firms before, and sometimes they won't give me what I'm doing until like 10 minutes before I'm supposed to go into court. So I'm like, I can maybe read this, but I don't know. I'm just gonna, I don't know. So I do feel for this guy. Now, this dude is partners with this guy, so he should have more of a familiarity. And this is a very high profile case. And this is
an emergency hearing. So while it may not be weird in a normal coverage case, y'all were doing an emergency hearing that y'all called for.
Exactly.
Could have been prepared.
Exactly. If you're the one who's the movant in something like this, you better damn well know your facts, and you better be clear. Also, you better have access to your client. And guess what? That's going to become. So 2 things here. Foreshadowing. The partner is traveling and is in an airplane, unavailable. So the dude that wrote the motion is unavailable and we can't contact him. And we don't know if we can get a hold of Alex Jones.
Right. Allegedly
supposed to be resting at home under the supervision of his physician. So there's some gold in this transcript. There's absolutely some gold. Now here's the thing. So the judge is really giving these guys so much rope, so much friggin' rope. So basically these guys roll in with this motion saying it's an emergency. He cannot be compelled to testify. He can't do it. He's sick. We've got this letter, but y'all can't see it. I ain't showing that to you. So basically what they've done is they rolled in and they've said, we are not providing the plaintiffs with a copy of this motion that includes the letter. We're not doing that. Our client has not given us permission to share this letter. Now, a doctor's note typically is not something that should be controversial in this way. Like if you're asking for like if you're a kid and you have to prove that you were sick, you get a doctor's note and you give it to the school. This is not some, like, I know people are like, oh, it's a HIPAA violation, but not
if I hear that shit one more time.
I know, right? But not if the patient requests the stuff to be sent to another party. It's not a HIPAA violation. It's a third party has to do it. So he's basically, his position is, I've got a letter. You can't see it right now, Judge. It was not part of the filing. The other party doesn't get to see it. We don't have permission from Alex Jones to tell you what the letter contains in open court. We do not have permission to even verify who the doctor is or if they're licensed and in what state.
We don't have permission to verify information.
Yeah. What they ask for.
But isn't that what we do?
Literally. What these guys rolled in and had the audacity, nerve, gumption, and gall to say is, Judge, we only have permission to bring you a letter to look at in camera so that you can determine whether or not it's valid and can then make a decision about whether or not this motion should be granted. Of course, plaintiffs are objecting all over the place.
Deny it, kick out the motion, kick it out.
You would think this judge does not do that. This judge gives these people hella rope. So the first issue is the judge is like, listen, y'all, I ain't really about to go in camera to look at this letter. So let's see if we can break down what we can deduce from the letter without sharing anything that you have not been entitled to share. So the court is like, okay, ball in your court. I'd be interested in hearing from you as to what restricted activities besides the purported recommendation from the physician that your client not attend depositions. So the judge is like, okay, real talk. A doctor's note should indicate what activities are restricted and why.
Right.
No working, no lifting heavy objects, no driving, no going to like what things are you restricted from doing?
Yeah.
And so this is the attorney, I shit you not, this is the attorney's response. Yes, Your Honor, I'm not aware of any other restricted activities other than to say he's remaining home under the supervision of this physician, as we understand it, pending the results of tests that have been arranged. No indication of what the tests are or what the condition is or what the restrictions are. So this is what the lawyer says. The judge says, okay, and do you have, and I'll hear whatever argument that you might have, but do you have any like evidence that the court can hear? So here's what the lawyer says. Your Honor, we did receive a letter yesterday afternoon here at the office from the physician. Again, that is, we've been authorized to share that with the court in an ex parte, meaning outside of the actual court, outside of everybody being present, all parties being present, for an in-camera review. And I can provide that to the court. However, the client has thus far, as I understand it, not authorized disclosure to the other side. Okay. And the court says, so you're looking to admit this letter? And they're like, oh yeah, Your Honor, for review in camera, you know, similar to a motion for confidential records. And the court's like, okay. So like before I talk to the plaintiffs and see how they feel about this, because I'm sure they feel some type of way about
strenuous objections.
Eye rolling. If only like this is just the transcript. If only the transcription was like audible eye rolls from opposing counsel. Like,
I mean, this lawyer is lucky that he wasn't up against us, because the side eyes and the, well, you probably would have started yelling. But anyway,
this ex parte, I was like, objection, no ex parte stuff. If you have the audacity to file a motion, you better give me those exhibits. And there is no reason why a doctor's note should be treated in this way.
Right.
Because here's my as an attorney, when I tell a client what kind of documentation I would need to present to the judge, I give them specifics. And I'm like, if there's something you don't want to reveal, tell the doctor specifically how to structure the letter. In fact, I might draft a copy of the letter, give it to them, and have the doctor sign it, so I know what it says and I know it's not revealing anything that I don't want revealed. But this idea that you can just come in with some purported letter and then just demand everybody accept it on its face when we don't even get to see it, that's some A-level bullshittery is what I gotta say.
Okay, go ahead.
So the court kind of goes back and forth and is like, I want to address this in camera stuff. Okay. Now, Robert, how often do judges do in camera examinations?
I mean, it hasn't been common for me, because the point of court is that it's open and people's rights are vindicated and protected.
Exactly. Now, in there are times when people, like when we might go out of the courtroom to confer with the judge, or we might approach, like in some courtrooms, like if all the lawyers and the judge want to confer and they don't want it heard, they'll put some kind of a device on so people can't hear. But that is not what this is about here. This is about somebody trying to get over and failing miserably. So the court says, okay, so you're saying your client has not authorized you or your firm to disclose the name of the physician or the medical diagnosis. So what's changed since the filing? And so of course there's a lot of hemming and hawing. You can imagine like this lawyer literally is standing there with his dick in his hand. Yeah. I mean, obviously he's sweating. You can tell. I believe the file was that we weren't authorized to disclose that to the opposing parties. However, we have authorization to disclose that to the court, and we've asked for that to be done ex parte in an in-camera review. But as I conceptualize it, that's what's being requested. So he don't even know what his client is asking for. He's just kind of making it up as he goes along.
Lawyering on his feet.
And I do have some, and we talked about this before we came on to record, and I do have some respect for this dude, because I feel like I've been there. I'm in front of the judge and they ask me a question and I don't have the information. And I'm just like, judge, based on the information I had at the time and on information and belief. And, I ain't talked to my client in a minute, but based on my understanding of the circumstances, and the judge will just do that like, really, counsel?
All right. No, thank you.
All right, we'll just set this we'll give you another date because just come back and be prepared, counsel. Like this is just not acceptable. The amount of times a judge has done that to me, like, counsel, please. So they go back and forth a little bit, and they're like, again, they're saying we're not authorized to say the name of the doctor, we're not authorized to say what they do or what's restricted. And so the judge is just like, the judge is like, really, come on now, like, I don't understand. Your last filing in the official file, your client had not authorized you to disclose the medical condition, and they have not allowed you to disclose the name. So what can we really do here? Like, how even is an in-camera looking over of this letter going to help? I mean, it sounds like the fact that you're not authorized to share any of that stuff in open court is concerning.
Yeah.
Because what is in this letter? Is it because there's so much in the letter, or could it be
there's nothing?
Bullshit. It's bullshit. So, legal ASMR. It's bullshit. So basically they said, so this is what I love. Like, you're now authorized to submit it in camera. And I haven't heard from the plaintiff's counsel on that yet. And you've not disclosed that to the plaintiffs. This is news to them. And they're like, yeah, this is the first time we're having any discussion with plaintiff's counsel. They rolled into court, not having forewarned the other side that this is the bullshit that they were planning to do. So, and even this guy's like, yeah, for real, honestly, I mean, I didn't really even know until I had a conversation with somebody else in my firm to get me up to speed. So I basically am making this up myself. So, so here come the plaintiffs, and they're like, yeah, I had a conversation, and they relayed to me that there was a letter. They'd be looking at it to submit it ex parte. That's all we know. And the court is like, okay, got it. So now is when there's this really fun back and forth. Okay, judge, are you authorized to disclose even the name of the physician, or is that something your client is not even willing to share? Again, not with the opposition, Your Honor. All that information is in the letter, which I'm enclosed, which we can only disclose ex parte. All right, well, the judge says, yeah, well, that is not something under seal that can be filed, so that that it would be confidential or not. You could potentially ask for it to be under seal so everybody could see it, the opposing counsel could see it, but it wouldn't be released to the public. So why you didn't do that?
Right.
And he's like, well, I just don't have authorization. Like, okay, all right, well. So here comes Attorney Matei. And Attorney Matei is coming in hot. We oppose, Your Honor, any ex parte in camera review of the letter that purports to justify Mr. Jones's excusal from his deposition. We think the procedures have been followed in this case to date, protect sensitive information, including medical information, and we'll follow that. If you want to seal it, that's totally fine with us. We don't have a problem with that, but you have to give us a full and fair opportunity to oppose whatever bullshit this letter might contain.
Absolutely.
You can't just come in here and be like, yeah, we got it, but you can't see it and we can't talk about it. Not going to do it. So they're like, the plaintiffs need to have a full and fair opportunity to oppose the requested postponement. How can we do it if only the judge gets to look at the letter? That's not fair.
No, it's not.
Not equitable. And we can't rely on what's in that letter or even the judge's understanding of the letter. Not fair.
Right.
Not fair. So now here's what the judge, now this is when the tide starts to shift, and you can tell that the judge is starting to feel some type of way about the defense. So the judge says, all right, so Attorney Smith, defense attorney, and I'm going to give you as much time as you need, usually a bad sign. I really don't mean to cut you off, but without having to, without the necessity of an in-camera review, because I want to see how detailed this letter is, can you confirm this is from a licensed physician? And the attorney says, as I understand it. Now, when you say something like, as I understand it, that's not a yes.
That's basically I have no idea, Your Honor.
Because he don't. I don't even know if he read the letter. So the judge says, okay. And are you able to say what state the physician is licensed in or what states? I am not, Your Honor. Again, we got this letter yesterday. I mean, okay. How long does it take to read a letter, typically, Robert?
A minute or less.
And like a doctor's note saying you can't go to volleyball practice tonight because you're sick shouldn't
That's
take
like a paragraph.
Yeah, literally. So this idea that like, oh, we got it late in the afternoon, I didn't have a time to read this letter, so I couldn't even tell you if the doctor his name is on there or what state they're licensed in. Not buying it.
Not in 2022 when we got all this technology and all these search engines.
Oh, this will come in. I'm glad you mentioned that, because the ability of being able to figure stuff up with the quickness because of technology becomes rather important in the disposition of this matter. So this guy's hemming and hawing. He's like, oh, we didn't get the letter until yesterday. We haven't spoken with the doctor. I'm covering this because my partner's in flight. And the judge is like, okay, I understand. But from the letter, I cannot glean where the physician is licensed or if they're currently licensed. Is this correct? And the attorney says, yeah, that's correct from the letter. So he admits that they don't even say if they're currently licensed doctor or where they're licensed. I mean, you might not say where you're licensed, but at least you would give some indication that you're currently a practicing physician.
But also, attorneys look for information. Like, I'm not going into court with some weird ass letter and I haven't called the doctor's office. I haven't seen where they're practicing. Like, I need some information. Otherwise, I'm not taking it to court, but that's just me.
And this is for their own clients. So they should have, by all rights, looked at this letter carefully and talked to their client and made sure that they got something that could stand up in court, because this is just some real shoddy lawyering, as far as I can tell.
Isn't part of our job advising people to not do bullshit?
Well, and again, like when you are somebody like Alex Jones, you likely have blown through many attorneys. You've probably blown up a lot of relationships because you're like not exactly an easy client to deal with, shall we say. You're a problem child, and these might be multiple, like we don't even know how many attorneys they've had before at this rate. So, but in this case, we don't even know if this physician is licensed. And the judge asks, okay, and I could not tell from this letter where the physician practices, true or false. Attorney Smith says true. All right. Does it have an address for the physician? Attorney Smith, no, Your Honor, it does not. We got his name. We don't know where he works. We don't know what state. No address.
And we didn't bother to look it up, Your Honor.
And yeah, they could have easily looked it up. That kind of stuff is public record, okay? They could have easily go. See, here's the thing. Because we deal with clients all the time, and we have to get them to provide documentation to us. And a lot of times the documentation that they provide to us is incomplete.
Yeah.
And so we have to go in and get the answers to the questions, because we can't roll in with a half-assed pleading and say, yeah, judge, client wouldn't tell me and I didn't feel like asking, so whatever, it is what it is. You know, like that's malpractice. That is not zealous representation. That ain't even representation. That's just sloppy.
So get that bullshit from us.
Right? I mean, our clients tend to have the opposite. They're like, leave me alone. I'll get you the fucking affidavit. God, get off my back, Mom. So, gee, it's Friday. I don't want to do it. So the judge says, just give me a moment. All right. And you can hear the glasses coming off and the nose pinch happening. So it doesn't address the state the physician is in or whether he's currently licensed and where he's located. That's it in a nutshell. Attorney Smith, correct, Your Honor. And the judge is like, okay, so does it address how long they've had a patient doctor relationship between these guys? It does, Your Honor. Okay, are you able? And the judge says, I don't want you to get yourself in a pickle. Now, when you hear that, Robert, what's going through your brain?
The judge is like, this letter is a bunch of bullshit and you finna lie to me.
It's bullshit. So the judge says, are you able to state whether the letter indicates there's a current patient-physician relationship or how long that relationship existed? Is it 2 days or 25 years? And Attorney Smith says, Your Honor, particular length of time is not stated. However, it appears to be a current relationship. So I guess we're Facebook official, but it's complicated.
Oh God. Oh God. Oh.
The judge says, are you able to tell me whether or what other restrictions besides the depositions are contained in this letter? And this is where it starts.
Reasonable question.
Thank you. Thank you. And here is the answer. This is where it just starts to all unravel for this dude. And we are nowhere near the end of this. There is so much. So he says, again, Your Honor, without getting too deeply into it, there are other restrictions there, including remaining home under doctor's supervision pending testing results. Okay, judge. All right. So can you tell me whether there's any physical restrictions? You know, don't work out, don't exercise. Are there any driving restrictions, any work-related restrictions, or does this just restrict this deposition? So like, I'm not going to address any of the other things this guy can't do because he's under my supervision. But the number one thing he can't do is sit for a deposition.
What a ridiculous concept.
Oh, it gets better though.
You must mean worse by better. But
oh, it gets so much worse. And I'm living for it because I ain't the one in the hot seat. And I could just sit here and be like, oh, child. You just fixed your fingers to type some bullshit and you just, and it's for the whole world to see it. So Attorney Smith has to say these words. Well, Your Honor, I think there is a general restriction regarding remaining home. And the judge says,
wow.
The judges. So I guess I'm trying to figure out is whether, and I don't know if Mr. Jones, for example, has a home gym. So I understand that many people have a home gym at home. Does this address, so I understand the recommendation is to remain at home. Is it remain home and don't physically exert yourself? Reasonable? Reasonable. Smith, Your Honor, it doesn't specifically say remain home. Don't physically exert yourself. Again, it's more general than that. It could certainly be viewed as encompassing that. Don't get yourself in a pickle, Mr. Smith.
I mean, you know what? This lawyer is really thinking on his feet.
He is. I mean, I
he came in there for nothing.
He got nothing. And what else would we do? We would do the same thing. Like, as I'm reading this, I'm like, he's wrong, but I would do the same, you know?
What else you gonna do?
What else are you gonna do? Like, I think it could be read as encompassing it, which I guess it could technically. And the judges, does it address whether Mr. Jones, the recommendation is that he not engage in any work or, this is important, work-related activities while home. For example, a lot of people be working remotely.
Mm-hmm.
Now, let's just break here for a second, because Alex Jones, he has a daily program. I mean, I wouldn't call it a program. It's a rant cast, but he used to put it on all the different social media platforms like YouTube. He might stream it on whatever platforms he's allowed to stream. I don't know if he's allowed anymore. He might just do it on his website. But, you know, during the pandemic, a lot of people who had TV shows, I mean, everybody basically, they started broadcasting from home.
Right.
So my question in the back of my mind is, does he have a home studio? Because where do you think we're broadcasting from right now? I got a green wall behind me. I got lights. I got all the things. I have a home studio.
Yeah.
You got one too. So I think what the judge is getting at here is, even if he's to remain at home, is his ass still working? And how do you square, I'm too sick to be deposed, but not too sick to scream and yell and sell useless supplements on my YouTube channel?
Totally reasonable question.
Okay. And he wants to know, does the letter address whether he can work or not? Very reasonable, you know? Yeah. So here's where the turn happens. I say that because, as I'm sure you saw in the objection that was filed by the plaintiffs, there was an indication that Mr. Jones was live on the air for 4 or 5 hours yesterday, in addition to other broadcasts. So they're claiming he's too sick to be deposed. He's got to stay home under strict supervision of a doctor. But yet somehow, in the midst of his sickness and grappling with his illness and his problems with his health, he still was able to live cast for 4 to 5 hours.
I would be so mad at my damn client.
I hope I wanted to say these bitches, but I guess I'll give them a little bit of credit. These attorneys, I would hope these attorneys would have checked, because first of all, if you represent Alex Jones, you not only could, but should know he's on that InfoWars site all freaking day.
They know that. That's how they get paid.
Exactly, because those supplements aren't going to sell themselves. Somebody got to buy this like horny goat weed out here. They're not even able to say who the letter is addressed to, because it was addressed to whom it may concern. So, then the judge is like, can you tell me what the hell is in this letter? Since we're talking about what's not in it, can you tell me what is even in it? How long is it? And this actual exchange happens. All right, just tell me how many sentences in the letter. All right, if you'll hold, I'll count them. 7 full sentences, Your Honor. And now we're getting to the authenticity, because the judge says, so for example, Attorney Smith, if the court wanted to determine the authenticity of this letter, how would the court go about doing that? Exactly. And he goes, well, Your Honor, I suppose, as far as genuine would be the testimony of Attorney Pattis, who's his partner.
On the plane. On
the plane, right? We could have him, I guess, provide testimony. And the George says, well, I don't have testimony. So, well, I guess we could ask, well, can we just go in camera and look at the letter and see what you think? And so at this point, Attorney Smith says, we've been answering questions back and forth. So the court says, I know you want to continue to argue and respond to some of the issues that the plaintiffs raised in their objection. So take your time. Never a good sign. Never a good sign. So this is where lawyering can shine through in your moment of great need. Yes. Sometimes you pull something out of your deepest recesses of your soul, and that's what Attorney Smith does right here.
I'm terrified.
Well, Your Honor, I know that there's a claim here that this is a threadbare attempt. Well, I'm not sure it was a paltry attempt, but they're saying there was a threadbare and flimsy attempt at delay. Certainly, I believe that opposing counsel is aware that Mr. Jones has appeared for numerous depositions in related cases, so he has submitted himself before. So I think that despite what the opponents might say is suspicious timing here, he does have a history of actually appearing for depositions and providing testimony. I think it's an unfair claim to make. We're willing to submit this to the court for review. The procedures, I think, that have been suggested by the plaintiffs as being sufficient to seal and maintain confidentiality. Our client believes, given what's happened in the Texas cases, now here's where he comes in and says, we don't think sealing is adequate. It's going to get leaked. So they don't agree to sealing because there's some allegation that in Texas some stuff was leaked. So he lacks faith. Alex Jones lacks faith that the sealing procedures would adequately protect him. So he's asking again, like, you still don't want to do this under seal? And he's like, I don't even know who this doctor is or what the condition purportedly is.
Right.
And so here's Alex Jones is now Alex Jones being afraid of public knowledge is friggin' crazy because he literally gives all his business all the time. And currently, half the time when he's on his live broadcast, he's just fundraising for his legal defense for this particular case. He's his own worst enemy here, but now his lawyer is so valiantly trying to, to like pull him out of the fire. Like the judge is saying, at a minimum, could you exchange a copy of the letter redacting the name of the doctor and redacting the name of the condition? And the lawyer says, I don't have authorization for that. Not even a redacted letter. And he's like, and I'm not sure if we redacted things, if that would even, like, he's basically saying if we redacted it, the 7 sentences would all be redacted
out. We just give you a black box.
And at this point, here's where the lawyer pulls out his ace in his sleeve. I'm sorry, I'm getting a message here that says bad network quality. The diagnosis is 404 network error.
Oh my God. So this was happening over Zoom.
This was Zoom. And this is the thing, like, why couldn't he just do the deposition over Zoom? You could do that. It's totally
that's what I've been sitting here thinking.
But nobody ever recommends because like he was being told he had to do this in person. And because now, like Texas, everything's in person. Well, a lot of it, apparently not this motion, but an emergency motion you probably would do remotely anyway right now. So they finally figure out the Zoom issues. And the judge is like, okay, for those of us who are just joining us, here's the recap. So you're only authorized to request an in-camera review or nothing. You're not authorized to redact the letter. You want the plaintiffs to see nothing, even if it's redacted and without the medical conditions and the name. That's correct, Your Honor.
Wow.
So the judge is like, all right, let me shift in my seat here. Let me get ready. To talking about how or if this letter is genuine. I mean, how do I determine this is genuine if it's just a doctor giving a name? It's like, there's no address, there's no state, there's no name. I don't know what jurisdiction. I don't know if this person's real. How am I supposed to know if it's genuine? And again, Attorney Smith, hemming and hawing, he's like, if the court wishes, we can attempt to get affidavits or like other means of putting forward evidence. Like, Robert, if you're filing an emergency motion, would you come to the court with this little evidence to support your claim that this is a true emergency and that this actually must be heard?
Ma'am, I wouldn't even show up to do coverage with this little information for somebody else's case. Like, you know what? Because I am a practicing attorney, I understand what's happening here. But my God, I would be so embarrassed that I put my name on the record and people are going to see this.
A lot of people, because it was going all over law Twitter yesterday. I read this during my lunch break.
I'm going to be real. If I was, Kimber, I know that you would never do this to me. If you ever did some shit like this to me, I would cut our soul connection. Oh. Because this is terrible. Like, wow. How do you do that to your partner?
Yeah, and that's the thing. It's like this, you guys are partners together. Like, how are you gonna play him like that and be like, well, he up in the plane. I don't know, y'all. I don't write this shit. It's not me. Like, dude, why don't you just like not do this? If you don't have enough, what we do is say, listen, part of being a lawyer is not just doing whatever your client says.
Right. Part
of being a lawyer is telling your client not to do some crazy bullshit, which this is. And I found, to my chagrin, the last time I had to file an emergency motion, which I even did tell my client, I don't think this constitutes an emergency. In fact, I know it doesn't constitute an emergency because this particular instance, there's a local rule that says this shit ain't no emergency. Don't even try and come to us with this bullshit. But she just insisted and insisted. And I was like, well, I like money, so I'll take it. And I said, listen, just be prepared for us to lose because we're probably going to lose. And of course we get in there and the judge is like, counsel, this is not an emergency. And I tried most valiantly. I did the best that I could. And the judge was like, no, not an emergency. Get out. We're done.
I think that in that situation it was. I understand that the judge didn't agree, but I felt like, and that's why I pushed for us to do it because it was a time sensitive.
It was time sensitive. And we did work out a resolution. In that case, I felt like in this case, I was ready. I had everything. I had all the arguments I could possibly make. I didn't come in here and say, like, Your Honor, I can't tell you why it's an emergency. My client hasn't authorized me to do that. I don't have an affidavit or any proof or any reason or any kind of filing or brief. All I can say is, if you let me show you something in a breakout room that just us see, then you should fine for me. Oh yeah, opposing counsel can't see it. Okay, y'all, no, that's a hard pass. So again, they're hemming and hawing and going back and forth. And now he's saying, oh, we didn't get this letter until 3:30 and that didn't give us chance to, like, if I got some bullshit letter that literally says, to whom it may concern, Dr. Bob, Alex Jones is under my supervision and cannot be deposed. Love, Dr. Bob. And that's it. That's the whole sentence. If I saw some bullshit like this and you expect me to go in front of the judge the next day when all eyes are going to be on this because it's a high profile case, I would say no.
Yeah.
I wouldn't do it. I wouldn't do it. I would respectfully go into court and be like, Your Honor, we're gonna withdraw. I would get opposing counsel, like, we're gonna withdraw this motion, and we're just gonna go in and say, Your Honor, we withdraw. Strike it. Just strike the whole thing.
Right.
Just strike it. His ass is gonna get deposed. That's it.
Right, that's it.
Your ass is getting deposed unless you can get me a better letter right freaking now.
And we would definitely say that to our clients.
I would use saltier language, to be fair, much saltier, much saltier. So now, after all of this hullabaloo and buffoonery has just passed, and the judge is over here like, I cannot even believe this is my life today. Like, how did I get assigned this case? What happened? What timeline are we in? So, the judge is going back and forth and just trying to figure out, what does at home under doctor supervision mean? And because to my mind, when you say you're under a doctor's supervision, it doesn't mean that the doctor is literally in your house, like watching you like, hey, Kimber, didn't I tell you no exertion? Why are you yelling at the screen? Stop watching Daredevil. Okay, we know he's a bad attorney. Don't watch that shit. It's getting your blood pressure up. Hey, Kimber, eat more vegetables over here. Like, under doctor supervision doesn't mean he's in your house, literally, right, like, I'll be watching you. Like, he's not Sting. He's a doctor. So under supervision means they tell you what to do and you're supposed to do it. And you're supposed to take their recommendations under your own auspices. But is that what Mr. Smith says? Oh, no. So basically now what the judge is trying to get across is what constitutes under doctor supervision for the purpose of this. Right. And so he's like, was Mr. Jones examined or treated by the physician? What did they consult? When was the last time he had some kind of contact? And the attorney says, I think yesterday. And he's like, okay, so what I'm trying to reconcile is, you say that the last time you heard from this doctor was 3:30 yesterday when he contacted your partner but what the plaintiff saw, okay, timeline. So 3:30 p.m., the day before this motion is being heard, the doctor apparently is having a consultation with Alex Jones. Meanwhile, the plaintiffs in their opposition motion, they say he was actually live broadcasting at the time he's allegedly supposed to be getting treated by the doctor.
So he didn't even read the response to the motion?
I don't think he read anything, because I don't know if he knew that his partner was supposed to be traveling. Like we talk to each other several times a day to make sure, like, even though I'm not actively on all your cases, I'm always discussing everything so we can know where we talk about all of our cases, so we know where we're at on every case. Yeah. I know not everybody operates that way and they can't necessarily do that, but this partnership, I don't know if these bitches talk to each other, frankly. And after today, I'll be surprised if Mr. Smith and Mr. Pattis are still friends, because they kind of screwed the pooch on this one. But the doctor says, or the judge says, so I'm just trying to figure out, it just doesn't make sense to me that he's with his doctor in the middle of a live broadcast. And you're telling me that on the one hand, he's supposed to stay at home, he's restricted. But on the other hand, I have a citation, and this citation is a timestamp image of, so what happened was Alex Jones, he played himself. He actually refers to an article that came out at a certain time on that day. It's almost like having a proof of life photo with you standing next to the newspaper from today, so they know that you're still alive. So these are good attorneys. I like these plaintiffs. They went in there and they're like, hey, judge, he referred to this article, which came out at 9:17 a.m. on Monday. And at that time, he claims to be under a doctor's supervision at home, but yet he was in his studio broadcasting at that time. And so the judge is trying to figure out the timeline here. So I'm trying to figure out, we've got the citation of the broadcast, and it suggests he was actually working all day yesterday, and he wasn't under doctor's supervision, and he wasn't even at home. So now listen to this sentence and tell me what that means in your vernacular, which I know you're going to do so succinctly. So I'm just trying to reconcile this based on what you've submitted.
So you need to get your damn story straight, because some shit ain't adding up.
Exactly right. He's like, you're telling me this guy is at home under strict supervision, and yet yesterday he was working all day at his studio. So something ain't adding up here. And at this point, Mr. Smith is like, yeah, I'm not sure that's anything more than the same argument that you have from them. Like the plaintiffs keep making this argument that he's always broadcasting. I mean,
well, it's the argument.
And here's what he says. I believe that while he was working, to the extent that this is working, that's some lawyerly shit right there. To the extent that this is working, and I mean, I put it to you, is what we're doing right now working?
Absolutely.
So he's like, to the extent that this is working while he was broadcasting, if he was broadcasting, I believe he was under the supervision of his physician. No, get this. This is when you know you have fucked around and you're about to find out. The judge says, so you're taking the court's time, right? And we did this on an emergency basis, and I'm not sure I'm getting the information straight, but I don't see why there's any reason why any of this information should not be provided to the court. So to your knowledge, if you don't know, we can take a recess and you can sure find out. To your knowledge, when did your client broadcast live yesterday, if at all? Do you know that information, or is that something you can find out? And Attorney Smith says, oh, okay, as I understand it, he was broadcasting at various points yesterday. So he admits it. He admits it. So he now admits, like, he now is basically, because he's an officer of the court, he can't lie to the tribunal. He can't lie to the judge. So the judge sees the problem here, which is you can't be at home under supervision of a doctor simultaneously live streaming your show for 4 to 5 hours. And the judge put it together quite quickly. I don't think you need to be a judge to figure this out. I feel like a 12-year-old could figure it out, but then again, what do I know?
12-year-olds.
I actually do know quite a few 12-year-olds, more than I should. So was he broadcasting live after this purported recommendation from the doctor that he not attend this deposition? I'm just trying to figure out, is the only restriction basically that you're not restricted physically, you're not restricted from driving, you can broadcast live, but you just can't attend that deposition? So, Your Honor, I'm not sure. I don't think that the letter was sent to us that it was that it would delineate what the restrictions would be. And the judge is on him now. The judge is coming in pretty hot. Like, so he's permitted to broadcast live from home, for example, based on your review of that letter. And Mr. Smith says, based upon my review of that letter, I would say so long as it doesn't exacerbate and doesn't conflict with what the results of the pending results were. And you know, the judge is kind of going back and forth with him, and the judge at one point is gonna make a comment like, listen, I've watched a lot of this guy's videos. There's no way you can tell me that what he does, that his performance would not exacerbate his condition.
Right, whatever it may be.
He screams and yells. He gets like so red, like every single vein is like bulging out. Like he looks like his high blood pressure is through the roof every time. So there's no way you can claim to do what you do and not exacerbate whatever condition that you have, unless your condition is like gout I guess. We don't know because they won't tell us. It's I've got to injure. I don't know. Like what possible sickness could he have that he could go online and broadcast for 5 hours straight, but somehow he can't sit for 3 hours and be deposed when he doesn't even have to yell and scream?
I know what it is. He's filled up to the brim with shit.
Well, I mean, that could be. I mean, he probably doesn't need a lot of fiber. He probably doesn't need a lot of fiber because he probably just eats raw red meat all the time. Yeah, and salt and water.
That's a motherfucker right there.
Yeah, right. There are people that do this. They call us food burners because we cook our food.
Oh, okay.
Listen, it's a thing. So the judge keeps going back and forth. And he's trying to figure out what the hell is going on, and he just can't get anywhere with this attorney. And now here's where the judge comes in and says, "Listen, you can't tell me what's wrong with this dude. You can't tell me what any restrictions are. You are just telling me basically what needs to happen is that Alex Jones needs to be under the literal suit. Like he needs to have his doctor in the same room with him at all times." And so here's what the judge says. Okay, so is there any reason then, if the physician is accompanying him during the broadcast and at his home, because that's what the other side is alleging now, that I believe the doctor is at his house and is with him, which I do not buy. I do not buy that. But he's like, if the doctor's with him at home supervising him, why can't he come with him to the deposition? I mean, he says, wouldn't be the first time this has happened.
Fair question.
I know. And so Attorney Smith says, that I don't know, Your Honor, but I don't suppose that would be remaining home. And, we still don't have these test results for the test that we don't know what they're about because they won't tell us. So he's like, he says these questions would be better put to the physician and the doctors, but you haven't offered it. Like you should have brought the doctor then. Why didn't you bring the doctor? And at this point, he just kind of gives up. He's like, oh, I got nothing. I got it. You know what?
Especially, see, when I first heard about this, I didn't realize it was on Zoom. But especially now that I know it's on Zoom, where is the doctor? Give him the login info and get his ass on Zoom.
Yeah, because they could go in, like, if you still want to, if you still don't have you could do an in-camera chat with the doctor, or you could still get testimony that wouldn't reveal anything. It's just like, are you his doctor? How long have you been his doctor? Are you treating him for a condition currently? Is this a condition that requires him to restrict his activities? What are those restrictions? I mean, it wouldn't be hard.
Not at all.
I don't know why they didn't bring him in, but here at this point, now it's time for the plaintiffs to come in and do their bit. So thank you, Your Honor. Your Honor, when they say it twice, they're gearing up. This whole thing to me, and I'm choosing my words carefully here, is extraordinarily disturbing. Mr. Jones appears to be on the air right now, broadcasting his live show, The Alex Jones Show, as he does every day. I checked 10 to 15 minutes ago. He appeared to be on air, and I was just informed that the article he cited on the air was an article that you can tell from the broadcast was printed out today at 9:17 a.m. So, well, I sympathize to some extent with the position Attorney Smith is in, as do we all, Attorney Smith. We do sympathize with you, with all of your genitalia hanging out in front of the judge all day, even on Zoom. It was out there the whole time. What is clear is that this notion that Mr. Jones is responsibly complying with some unidentified physician's recommendations that be at home under his physician's care is completely bogus. Come through bogus. I haven't heard anybody say that word since like 1990. And it was Bill and Ted.
Oh God.
So
a throwback reference.
William S. Preston Esquire.
Oh Lord.
He should not be holding himself out as a lawyer. Anyway, that's fine. So although the plaintiffs do not have access to this letter, it seems obvious, both given the course of the conduct in this case and the fact that there's no evidence before the court other than statements of counsel, that the representation I just made based on my personal knowledge of having looked at the InfoWars website, I would encourage the attorney to pull it up on his computer right now. He's like, this is a dishonest attempt by Mr. Jones to avoid being put under oath and perhaps to some extent to disrupt plaintiff's preparation for the deposition. This is what I think it's getting to. They want to confuse them. Everybody's scurrying around. It's all hands on deck. We have to reply to this motion. We have to prepare for this motion. Guess what we're not preparing for? The freaking deposition, right? And you really want to be prepared for that, especially if you have a limited time. If you only have 3 hours, you better get those questions. You better be ready. You better be ready. And you better have exhibits. You better have stuff ready to go to refresh their recollection. You better have your binders. You better be ready.
Those damn court reporters, when you give them a time, that's the time. Because they need it.
And they will charge you. Like for something like this, I imagine these people are probably getting real-time reporting. Does a girl know about court reporting? Did a girl sell it for a period? Yes, she did. So the real-time reporting where they literally are creating a transcript simultaneously, that stuff can cost like $1,500 a day, right? Yeah. That is not cheap. So you are not wasting these people's time. Yeah. So like, this is very serious. And I think this is a great argument, honestly. I mean, number one, they came with the facts. They're like, he's doing it right now. If I shared my screen with you, you could see it right now. So then there's the prospect of testimony from the doctor, all while we're supposed to be preparing for deposition. So in our view, there's simply no basis for the court to make specific findings that he has some medical issue that will prevent him from testifying in a deposition. And that's literally all the plaintiffs have to say. They did not have to say, they didn't have to go back and forth and be like, well, I think the doctor's at his house with him. And, I don't know where he's from. And I can't tell you. And like, I don't even know if Alex Jones has legs anymore. Like, I couldn't tell you, So at this point, the judge spends some time going back and forth about, this is when you're in trouble, because he's basically like, all right, defense, you might just want to lodge this. He's basically talking about perfecting the record, and he's giving them an opportunity to perfect the record for appeal, because I think that's the indication. This is where the defense should know we lost, because he's allowing them to make a record for appeal, but he is absolutely not buying what this dude is selling. So basically the judge at this point is like, okay, we're going to take a recess and I'm going to accept the letter so it can be lodged and it can be kept under seal and it can be made part of the record, because we need to make sure the record is perfected. Totally fine. We'll come back at 3:00. Meanwhile, I'm going to look at this letter and I'm going to come back and I'm going to tell you what I think about this letter. So at 3 p.m., the judge says, all right, we're back on the record. I did review the letter. Thank you, Attorney Smith. You moved very quickly with that. And he's directing him again to lodge it with the court as sealed to make sure it's available for the appellate record. So Attorney Smith, you were going to report back to the court. Oh, wait, I forgot. There was something really great that I wanted to say. I think it's on here. Oh no, there's actually another recess, but there's something that this judge says that's just chef's kiss. But oh, no. First of all, he puts him on notice. He says, when we come back at 3:00, Attorney Smith, you will represent as an officer of the court whether or not Mr. Jones is currently on the air, as Mr. Maddie suggested. When the judge starts saying you're an officer of the court, you better be ready for a freaking sanction. Yeah. Because at this point, you're potentially violating the rules of professional responsibility and your license could be in jeopardy. Basically what he's saying, you better not lie to me. You better not come back here and tell me some bullshit, because I'm holding it against you. Okay. And the best part about it is he says, do you understand? You're muted. I love the Zoom stuff in the transcript. So at this point, he looked at the letter and now he asked Mr. Smith, okay, you were going to report back to the court whether or not Mr. Jones is broadcasting live. And Mr. Smith says, yes, Your Honor, it appears to be he's broadcasting. Okay, and I did not ask you, but I am going to assume based on what you've told me that he's broadcasting live from his home. Is that correct, to your knowledge? Your Honor, I'm not sure where he's broadcasting from. It could be his home. I can't tell from viewing the broadcast. I can see him on the live broadcast. So it could be a studio. It could be his home. We don't know. It could be his home studio. We don't know. So Attorney Matei says, Your Honor, I can tell because unfortunately I've had to watch all these stupid videos And he's broadcasting from the studio that he always broadcasts in, which does not appear to be at his home.
Yeah.
So at this point, the judge says, all right, we'll pass the matter for 5 minutes. Attorney Smith, you are going to come back and you are going to report to me whether that broadcast during our argument before we took the last break was from his home, which is what the indication is that he's confined to, or whether it's from his studio. All right. So we'll take a 5-minute recess. And Mr. Smith says, Your Honor, I will endeavor to do that. I'm just not sure I can get a hold of him in 5 minutes. Judge says, I have faith, Attorney Smith, that you can contact whoever you need to contact, whether that's Attorney Pattis or whoever else that the defendant has knowledge of. It shouldn't even take you 5 minutes to find out whether that broadcast was from his home or studio.
You need to send all the text messages now.
Get ready, because this shit's about to get heavy. Because what's being presented to the court is argument that he is remaining at home and needs to remain at home. And he can't leave his home. And God help everyone, in fact, if the broadcast was from his studio in light of these arguments, all right, we'll pass for 5 minutes. So
it's not looking good.
We're back on the record with Attorney Smith. Yes, Your Honor, I reached out to get in touch with Mr. Jones as well as Attorney Pattis. I believe Attorney Pattis must be in the air because it went directly to voicemail. I didn't get a response to his text, which is unusual. He usually responds to me. Like, I guess he knew you were screwed, and so he figured he just wasn't going to even bother. Mm-hmm. What can I do? I'm in an airplane. I can't tell. I don't know. I don't want to know. I'm not doing this. Sorry, bro. At this point, they're not soulmates anymore. At this point, the bond is broken.
Hell no.
He says, the number that I called for Mr. Jones is not available and he's not taking calls right now, which seems to indicate somebody's on TV. And he says, I didn't have any other way except for those 2 means to contact Mr. Jones. I'm simply unable to get in touch with him. So he's coming in with this. Here's his argument. And I don't think it's a bad one, considering it's all he's got. Mm-hmm. 5 minutes is not enough time. I am not personally able to determine from looking at the video if that's a home video or if that's from a studio. And I can't get a hold of anybody in that amount of time. And I don't think it's reasonable that I should have to.
It's all he got.
I mean, that's all he's got. And I think he made the best argument he could in this situation. So this is when we're starting to get into, this is potentially professional responsibility issues here. The judge says, are you troubled, Attorney Smith, by the suggestion from Attorney Mattis that the live broadcast that was going on during the argument where you were arguing that he was at home and that his physician was recommending that he stay at home, are you troubled by plaintiff's representation that the broadcast appears to be from his studio and not his home? So the judge is basically saying, govern yourself accordingly, counsel. Play stupid games.
Win stupid prizes.
And he done won the biggest, stupidest prize at the carnival. It's Alex Jones.
Damn.
He says, Your Honor, I suppose I would be troubled by anybody not following their physician's advice. I mean, who wouldn't? If in fact that is the case here, again, my argument is that this letter submitted to us would indicate was that he was to remain home under his doctor's supervision. I have no way to enforce that. Don't blame me if he don't listen. Although here's the thing, like, you have a duty to do a scintilla of due diligence to find out if you are presenting to the court and representing to the court that you're too ill and you're under doctor's care, that you can't go to a deposition. You better damn well not be able to go to and do other shit too.
Right.
And if while you're writing your motion, he's over on InfoWars screaming about how we need more magnesium in our diets because our dicks aren't hard enough, then that's a problem. He does that for real.
For real?
Oh yeah, he's got a whole line of men's supplements that mostly InfoWars is basically just to sell supplements. It's basically an MLM at this point, as far as I can tell. Yeah, I know, right? So he's like, I have no way to enforce this guy actually following his doctor. If they're not following it, I would be concerned. Who wouldn't? He really should be doing that. And here's where I think the lawyer just really did not do himself any favors. I am also equally concerned by an invocation that God help everyone, depending upon what should happen here. Frankly, I think that turns the heat way up beyond what is necessary in this matter.
Now you coming for the judge, bro? Not a winning strategy.
Bitch, that's not what you do. Like, listen,
you're already losing. Like,
you guys were the ones. You're talking about this is raising up the heat. Girl, you're the one that set the house on fire with this dumbass motion that you filed on Monday. You set the house on fire, and now you won't even let us call the fire department because we can't see the information about whether or not there's a fire.
Right.
I mean, girl, come on. That is just, I mean, I was kind of on Mr. Smith's team a little bit, just not because I think he's a good person, because obviously I feel like if you take this dude as a client, I'm a little bit concerned about you. But everybody's entitled to have an attorney if they can afford it and they want one, and somebody got to do it. I guess these guys were the unlucky ones chosen by the universe to do it. But this where he starts like, oh, how dare you invoke God? Like, you're in Texas. They do that shit. They'll invoke God giving you a sandwich.
True.
I mean, literally, like if you go to In-N-Out Burger, they've got Bible quotes right on the wrapper. Come on, they're invoking God all day long. I don't want to, please. So this is where the judge is getting into it. It's like, you better figure out, is he at home or is he not at home? And he's like, you're talking about all this ex parte stuff and you're refusing to make it available to the other side. Your argument is that he cannot attend the deposition because his doctor has recommended that he remain home, and he must remain home. That's what you're telling the court in a nutshell. He must remain home. And I have told the plaintiff, and I have the plaintiff saying he's broadcasting live right now. He was broadcasting yesterday. In fact, he never seems to not be broadcasting. He's on here more than Attorney Mike. And Attorney Mike be streaming all day. That mofo is never not streaming. I mean, he's a multitasker because, I mean, he streams a lot. So you're making representations to the court and submitting documents to the court that indicate he's remaining at home. But I have a lawyer on the other side saying he ain't at home, he in a studio. What would you suggest the court do with this situation? The shade.
You need to withdraw the motion, Your Honor.
At that, he should have withdrew it before it even, he should never have agreed.
Right. I mean, he should have read that motion and told his partner, you on your own, sis. But since he didn't do that, this is where you save yourself a little bit of dignity and say, Your Honor, we would seek leave to withdraw the motion and move on with your day. Move on.
But that's not what Attorney Smith does. He wants to have an evidentiary hearing regarding these conflicting versions. And he's like, I would like you to withhold a decision. Let's have an evidentiary hearing. And the judge is like, you're not at all troubled by the fact that you have submitted a letter from the court, from the doctor, that indicates his remaining at home. And one of the other lawyers has suggested to the court, he ain't out. Not only is he not at home, but he's actively broadcasting from a studio in total contravention of whatever this doctor purports to be saying he needs to be doing. The issue here is that this guy really likes In a Nutshell. Get a new metaphor, judge. So the issue here in a nutshell is that he can't attend these depositions. He's at home. He must remain at home. He is at home. Your Honor, again, I've submitted to the court a letter from a physician treating him who says he's to remain at home under supervision. It's dated of yesterday. I cannot control whether he's following the doctor's orders. I am not in Texas. I have tried to contact him to confirm. And the judge says, I'm not faulting you personally in any way. We didn't have to get personal, but apparently you took it that way.
Right.
I have you submitting ex parte information so the court is told he's remaining home. It's not complicated. Is he at home or is he not?
Right.
This is not Schrodinger's Alex Jones where he's only in or not in home until you open the house.
Right.
Right? Although Schrodinger's Alex Jones, I mean, like, that's an interesting proposition. I have to think about that some more. So he's basically like, there are all these live broadcasts going on right friggin' now. Is he home or is he not? Did he stay or did he go? So, you know, he says, it appears in fact that right now he's at the studio and that he is not remaining home. So if you're purporting to say that this man is so sick and in such need of home rest and supervision that he cannot attend a deposition, but he is completely not obeying those directives so that he can be on InfoWars, what is the court supposed to draw from that? What is the court supposed to do? And again, you know, at this point, the lawyer's like, I can't confirm it. I've never been there. I can't look at it and tell. I got nothing. And here's where the judge starts going in on his ass. I would think that you would have a duty and an obligation given the evidence that you submitted to the court by way of this ex parte letter and by virtue of your arguments that he cannot attend the deposition. Like, dude,
the bare minimum.
You did not come with the goods. You are basically legally catfishing us here. You came in all hot saying we got all this stuff going on, but when I show up, you're just some housewife. You're not a sexy young woman that I want to bone. You're a middle-aged woman I don't want to bone.
Stop it.
I did watch Catfish. That's literally the plot. I don't feel bad.
Oh, he is the movie.
Neve deserved that. He deserved that. He very much deserved that. So, so basically, you know, he comes back again, like poor attorney Smith. He has been through the ringer. You better believe that the minute that he hung up on Zoom, he went directly to a bar and got like 4 drinks in a row because he's still going. This man is like Captain America of bad ideas because he can do it all day. He says, as I say, 5 minutes was insufficient. I think it's insufficient for anybody. I don't sit and watch InfoWars. Frankly, I don't watch InfoWars. I'm here to represent my client. I'm presenting the evidence I have. The letter was yesterday. What do you want me to do?
Here's the thing. I feel for Attorney Smith on a level. Like, shared profession, I feel for you. But at some point, shouldn't you just cut your losses and be like, sometimes you just got to tell your client, we tried, we swung, we missed, move on.
Yeah. I can't, frankly, I'm surprised that the judge is allowing this much time to be taken up. I think the judge is
probably just like, what the hell is happening here?
Yeah. Yeah. So the judge here, like, I really appreciate this judge because I feel like other than the fact that they use in a nutshell a little bit too much, they know what's going on and they know the law and they're definitely giving both sides an opportunity to be heard. And you can see the amount of time that the defense has been given is literally like, you can't come back and claim that you were not giving a full and fair opportunity to have your issue heard. Not even a little bit. The plaintiff's barely making a peep over here because they're like, he's broadcasting, still doing it. That's all they got to do.
Yeah.
That's all they got to do. If you got the facts, argue the facts. If you got the law, argue the law. If, like Mr. Smith, you got neither,
pound the table.
Pound the table. God, Your Honor, unacceptable. How dare you? So the judge says, I think the reason that I took the recess was to give you, Mr. Smith, an opportunity to respond so you could actually represent to the court. And I was willing to take your representation, whether or not he was broadcasting from home or whether he was broadcasting from a studio. I certainly did not like what he allowed the other attorney to basically make his own representation based on what he saw on the video. I was giving you the opportunity to find that out and to correct what the court has been led to believe. So basically, again, he's like 5 minutes wasn't enough. And now we're going back to some other attorneys. And the other plaintiff attorney's like, Your Honor, I'd just like to note that I did look at the live stream that's going on. I can't verify if it's pre-recorded, if he's in front of a green screen. Some of it's pre-recorded. That would probably be like all the supplement stuff. But that's all I got to say. I mean, otherwise, you know, as an officer of the court, I make that representation. I have no other dog in this race. I have no other dog in this race. We just got nutshells. We got dog racing. We got God being invoked here. This has everything. So the plaintiff comes in and says, we've been arguing that this guy, they're over here literally. I wish we could have seen these guys in the back, because you're like, oh, it's on now. They're taking screenshots over here. They're like, screenshot at this time. I got like timestamp screenshots. I got screenshot. And they're saying he is definitely broadcasting from the studio he usually broadcasts from. Doesn't look like it's a home studio. It's his actual professional studio. And if you want further argument, yeah, we're prepared. But he says, I don't think there's any point to that. And the judge is like, all right, on the issue of whether the court has been misled on whether Mr. Jones is remaining at home, Mr. Jones, I have no doubt that you will take the necessary steps. And I mean this, I have no doubt you'll take the necessary steps to advise the court if in fact the court has been misled by your argument. And by the statement in the letter that Mr. Jones is remaining at home. So I leave that to you for another day. And if this does not need correction, that it doesn't need correction, but you'll look at the rules of professional conduct and you'll do, I'm sure, I have no doubt, you'll do what is appropriate and necessary in that regard.
Damn.
I mean, and then the judge says, okay, now we'll get to the substance of the motion. We ain't even been talking about the substance of the motion this whole time, about whether or not he can be excused from the deposition. And so basically, the judge has looked at the letter. He doesn't find it very persuasive. He doesn't really feel like if it was made public, that would really be a problem, but who gives a shit at this point? Nobody cares. He's like, okay, I have to say, I have no idea as to whether the letter that I did review in camera is genuine, nor do I have any way of knowing whether the author of the letter is currently licensed. I have been called upon to review records for purposes similar to this in camera countless times, but I have never seen, remember, 7 sentences. I have never seen one as bare bones as this one. This one did not have any letterhead. It had no address on it. It just has no indication of whether the doctor is a sole practitioner, whether he's in a group. It doesn't indicate what kind of doctor. There's absolutely no description of his practice. The court has no information besides a name, and there's no evidence besides that in-camera letter. The letter fails to address the length of the relationship. It does not say that they even examined Mr. Jones. Nothing else was submitted, along with the lines of a bill or a doctor's note. Anything that could prove that he's actually been getting seen, like some actual medical records. But yeah, you can keep those under seal. You don't have to share those, or at least keep them under seal so that we have access to them and we also can verify, that gout's really bad. Yeah, he shouldn't be, I can't think of what else. He eats too much red meat. I'm sure he's probably got gout. Anyway, so nothing else was submitted. This is not actually a medical record. It's just a bare bones note. With respect to the reasonableness of the recommendation that he not attend his deposition, and only the restriction really is he shouldn't go to a deposition, he should remain home and not go to. So basically the entire note is like, could my son please be excused from the deposition tomorrow? Did you ever have a time where you had a test that you really didn't want to take and you were like, please, can I just stay home from school? Because I just really want one more day to study. And of course you didn't study. I'm not saying that this happened to me personally. I'm sure I would never, but let's just say for argument's sake that you really didn't want to take that test and you had to get a note from your parent to say, yes, this person had an illness and couldn't come and take this test. And it's literally it's so bare bones. It's like, Kimber was not feeling great, so I let her stay home. It's not, and also she specifically was unable to take tests today. She could watch TV, she could kiki with her friends. In fact, she could go to the ball after they all got out of school, but she just has this illness, which I can't tell you about, and I can't share the illness or what the thing is, but the doctor, I can definitely tell you, the doctor said she can't take this test today. Sorry, social studies.
Right. No, absolutely not. My mom wasn't playing that game, but
So the way that just like point by point, like doesn't give me this, doesn't give me that, doesn't tell me this, doesn't give me that. There's no basics except for on my advice, he should stay at home. It appears to the court unreasonable to suggest that he can broadcast live for hours, even at home or from the studio, but he can't sit for a deposition. And I say that because in connection with motions that were filed several weeks ago back in this matter, the court was called upon to review portions of Jones's broadcast. And I would say that at least the portions of the broadcast that the court was required to review in connection with the motions, the Jones demeanor during those broadcasts was anything but calm. So so basically, it doesn't make sense that he can't sit for a deposition with lawyers. And this letter is some bullshit. He's broadcasting live. We all knew it. We all saw it. So for these reasons, the motion is denied. You can file whatever motions you want. I don't give a shit. That's cool. But I'll tell you what, that mofo better be in the deposition tomorrow as ordered right now. Now, Robert, can you guess what happened on Wednesday?
That motherfucker didn't show up.
Did not show. Can you imagine what also happened on Thursday?
He was broadcasting live.
Yeah, and he also didn't show there were 2 days of depositions. He didn't show for either. So guess who's filing emergency motions now? It would be the plaintiffs, and their motion is, we want you to order him to be arrested brought in for the purpose of this deposition. Absolutely. And what's your take on that? I mean, this is a civil case. Now, if you refuse to do what a judge orders you in a civil case, there is contempt. The judge does have contempt powers, but what's your take on, does a judge have jurisdiction to snatch a person up because they won't be deposed, arrest them to deliver them to the place where they're supposed to be deposed?
I mean, I got issues with arresting anyway, but aside from that, I think that this is a situation where it has to happen because he's like fucking with the court procedures. Like the case can't move forward. You know what I'm saying? I mean, I guess it could in another way, but if the depositions is just like, I don't do this kind of civil law, but if a deposition is just the normal way this shit goes so that you don't waste court time getting all this testimony and stuff like that, then I think that the judge got to do what the judge got to do.
Yeah.
I got my issues with arresting people, but
so this is
arrest him.
I mean, he deserves to be arrested. And if anybody deserves it, it's him. Although he's like one of those big, strong guys that the minute that he actually is challenged and actually has to face his consequences, he just melts. Because remember, one of his defenses early on was, I'm an actor, which is rich because he's the one who literally said that the horrible things that happened to those people was all acting and it's fake. But yet he's like, nobody who watches my show could take what I do as news. It's a character. I'm an improv artist. I'm a character like Borat.
Which is true, which I think is true, but that people want to believe it even if they don't.
Exactly.
People take inspiration from it. I mean, but let's be real. He's a horrible person. He deserves every bad thing that's happening to him. Like, fuck him. Like, I'm sick of his shit. Like,
well, that's the end of that saga. So we'll keep following this because I'm just like, morbidly curious about what's going on, just because I really want these families to see some justice. And I mean, there's no justice. Their children were murdered, but I mean, against him, I want him to shut up. Like the fact that after all these years and all these lawsuits, he's still out here saying the same crap. And he's literally like, he's sending his poor lawyers into the line of fire like cannon fodder to defend him to literally the best of his ability. And Mr. Smith, for all that he maybe, like there's a little bit of stuff in there that wasn't what I would do. He really, you can't tell me he did not defend his client to the hilt.
I mean, he did some on the fly lawyering. He didn't have anything to work with, and he made this shit into a saga.
Exactly.
So,
yeah.
That is lawyering right there.